So it's all about return to duty and how do we handle these situations. And again, to make sure that you are dealing with your employees in a way that upholds Canadian human rights, upholds occupational health and safety, that adheres to your company's drug and alcohol policy and fit for duty policy, satisfies all of those policies, those codes, those regulations, and treats the employees well. Your employees, you care about them. Some of them they've been with you for a long time. You care about them. Some of them like family. And you want to make sure they're looked after. If someone shows up to work and they've are under the influence, if they fail a pre-access test, a reasonable cause test, an incident test, and they may have an issue with substances, you want to make sure that that employee gets the proper help they need so that they can get back to work, so that there doesn't have to be disciplinary action, so that their family is well looked after. There's just so many things that go into this. So we're going to make sure that you get the answers that you've got to some of your questions today. And so how I've designed this is we've been doing this work for a long time. So we've been doing this. We just celebrated our 15-year anniversary this summer here at Assure. So I've designed this in a way to answer questions that the FAQs we've got from our clients over the past many years when it comes to this process. So again, a bit more about me. I'm the founder and CEO of Assure Occupational Testing. And what we do at Assure is we help companies write good policies around drug and alcohol testing is one way we do, one way that we support clients. We do drug and alcohol testing, occupational health testing, which what's under that one is we've got nursing staff, occupational health physicians that do medical assessments, audio testing, mask fitting, PFT, pre-employment work, make sure that your employees are ready for the job that you're putting them into, make sure that you're hiring the right people, putting them in positions that are a good fit for them. And we also do supervisor training, and we get to educate and do seminars just like you're at here today. So here's where we're going to go today. 4 things that I've got for us to talk about is 4 things we're going to cover today, all under the umbrella of return to duty. So first off, we're going to talk about, how as an employee, how does an HR safety manager, how do we kick off this process of return to duty? Well, it starts with someone being non-compliant with your policies, or they come forward and they voluntarily disclose that they may or they do have a substance use disorder, a problem with substances. We're going to talk about that. We're going to talk about what is a substance abuse professional assessment. We're going to talk about the details of a return to duty agreement, and ongoing, how do we look at what does compliance and monitoring look like when it comes to a return to duty agreement. So the first step is, again, how do we find ourselves in this process of what we call return to duty? So return to duty, what we mean by that is someone's been non-compliant with your drug and alcohol or fit for duty policy. They're non-compliant. We want to get them back to work. We want to return them to duty. So how do we do that safely? How do we do that with maintaining safety for the employee, safety for everybody else at work, public safety, environmental safety? How do we get this person back to work? Because we don't want to rush the process. We don't want to say, go off the basis of you failed the drug test. Do you promise you'll never use drugs again? Okay, as long as you promise, go back to work. We need to do a little bit more due diligence than that. So this is what we mean by return to duty is how do we safely and appropriately put this person back to work, keeping them and everybody else safe. So voluntary disclosure is another way that could trigger the return to duty process. So what we mean by voluntary disclosure is one of your staff comes to you and says, I've got a problem with alcohol. I've got a problem with marijuana, with cocaine, with pills. I've got a problem with substances, and I need some help. This is the ideal situation. Somebody comes to you and says, I've got a problem before an incident happens. That's the worst case scenario is they crash a vehicle, they hurt themselves, they hurt other people, they cause a spill, and then we find out there's a problem with substances. This is one reason why people will do pre-employment testing. is to get ahead of some of this. That's why some people do pre-access testing, is to get ahead of it. But best case scenario is a person comes to you ahead of time and says, I've got a problem. I want some help. What does our company offer me as an employee for help with a substance use problem? That's ideal. And your policy should have a section that states this, that encourages people to come forward and to get help for themselves. And if they do this, then they still get to go through the substance abuse assessment process. I'll talk about that a little bit more in a second. What is that about? So that's one way that triggers a return to duty is voluntary disclosure. The second scenario that triggers it is someone is non-compliant with your policy. So how are they non-compliant? Here's some examples or ways they can be non-compliant. They can have an incident. So an incident or a near miss. So can trigger it. So there's an incident, they hurt themselves, they hurt somebody else. There's an environmental damage to environment. Lots of different examples there around an incident. And your company might have a policy, or the site that you're on might have a policy that states if you're going to work on this site, if you're going to work on this company and you damage company property, you have an incident, immediately you must go in for a post-incident or a near-miss drug and alcohol test. So somebody goes in for a test and they are non-negative, or there's a positive drug and alcohol test result, that triggers return to duty process, or the substance abuse assessment step as well. Or there's a reasonable cause situation. So reasonable cause means someone comes to work and they show up and present themselves as not fit for duty. They could be smelling like alcohol, they could be staggering, they could be slurring their speech, they could be showing signs of being under the influence of a substance, whether that's alcohol, drugs, or prescription meds, prescribed or non-prescribed medications. So reasonable cause situation could also trigger this. There's a positive test result or a refusal to test. So what we mean by a refusal to test is a person says, or it's requested, the company requests that an employee participates in a drug and alcohol test, and the employee refuses. No, I'm not going. I don't, this is against my rights. I'm not doing this. They outright refuse. Those are examples of refusal. Another example of refusal is somebody shows up for a test. They come into the doors of Assure Occupational Testing, and they decide not to comply with the steps that we have in place to do a proper drug and alcohol test. So what I mean by that, what that could look like is we say you can't, in order to do a drug and alcohol test, before you're going to go into a secure washroom, for example, you need to remove your outer clothing, such as a jacket, a hat. You can't take a purse in the room into the washroom, because there could be ways that people could want to cheat on a drug test or alter a sample. So if they choose not to comply with that, then we won't proceed with the test. So if they choose not to comply with the steps and procedures that we have in place to get a valid, acceptable specimen, then what we do is we say we can't proceed with the test, and that's called a refusal to test, because they chose not to participate with our procedures. They're refusing to participate with the process. We can't get a verifiable, acceptable specimen from them. That's also called the refusal to test. So if a person refuses, they still get to go through the substance abuse assessment process. Because a refusal, an employee shouldn't be able to just say, refuse, I'm not going to participate in this process, as a way to circumvent the process and kind of get out of the testing process. They have to go through the process. Otherwise, how do you as an employer know how to properly accommodate them? How do you know how to properly return them to duty if you don't have all of the information? So that's what this process is about, is for you as an employer to get the proper information that you need so that you can, in full confidence, say, this person is now fit to go back to work. But you need that information. So you need to get them assessed. So a bit about policy before we get into substance abuse assessment, because the foundation of this whole process is a well-written policy. So there's a couple policies that we're talking about here today are drug and alcohol policy or a fit for duty policy. Your company might call it one or the other. You might have some, I've seen companies that just have a fit for duty policy with an alcohol and drug section that fits underneath that. And fit for duty policy might encompass mental health, sleep, having a proper sleep section in there about that, or your company might just have an A&D policy. So your policy gets to be well written. It gets to be written by somebody who understands and has studied drug and alcohol policies. So I say that to say this shouldn't just be something that's cut and pasted from something that you got off the internet or ChatGPT. ChatGPT will write everything for us nowadays. That can be a great starting place, and it should still be well written and reviewed by someone who understands policy, understands your industry, whether that's construction, oil and gas, and what your needs are. And also your policy gets to be reviewed regularly, whether that's annually, whatever it is. You should have mechanisms in place to make sure that it's up to date. Your policy also gets to be well communicated, at least when new employees are onboarded. Everybody gets to be provided a copy of the A&D policy, given a chance to ask any questions and have those questions answered. Another thing, a couple other sections that I think are really vital to have in your policy are prevention section, voluntary disclosure, and aftercare. So your policy, and if any, in all of the research that I've done of court cases, companies that have gone to court over drug and alcohol policy violations, where an employee has taken a company to court and they've gone through the court system. In all of the research that I've done, what the courts want to see in a policy, in an A&D policy, is that you as a company are writing your policy in a way that is for the employee as well as being for the company. So what I mean by that is some policies can be written very much about as you read them, they're read very punitive. If you violate the policy, here's the consequence. If you do this, here's the consequence, really punitive, consequence focused. That's important. That gets to be in your policy. But what the courts also want to see is, how are you helping your employees? How is this policy for the health and well-being of your employees? What are you doing to prevent incidents? What are you doing to encourage them to voluntarily disclose? So just by having a prevention section in there saying, we as a company care about the health and safety of our employees, the public, the environment. And here's our stance on substance use. We take action against substance use in the workplace. We encourage a safe workplace. We encourage our employees to be fit for duty, and we take action when they're not. And we encourage employees to voluntarily disclose if they have or believe they may have a substance use disorder. We've got programs in place to help you if you've got a problem. We've got counseling available. We've got EAP program available for our employees. Point being, this gets to be in your policy because if it not just if it goes to court for the courts to see, but also to foster an environment in your workplace that encourages employees to come forward. It's safe to come forward if you've got a concern, because if it's all about punitive and consequences, and if you step out of line, you're going to get in trouble. What that does is that really encourages people to not come forward and share anything, because it encourages a fear culture, if you will. There also gets to be an aftercare section in your policy. So if someone's in a violation of the policy, they go through the SAP process and the return to duty process. What's the ongoing aftercare long-term support that you're offering to your employees? And of course, there also, lastly, the last point here on the screen is there gets to be consequences for people who are non-compliant with your policy. People get to know that if you're not in compliant, if you choose not to comply with this, there's going to be consequences up to and including termination for cause. That gets to be in your policy, up to and including termination for cause. So now let's look at what is a substance abuse professional assessment. So one of the key and key pieces of the return to duty process. And the key starting place is this person who's been non-compliant with the policy, or they voluntarily disclose that they have or may have a substance use disorder. The first step is we need to get that person assessed by a professional. You may have seen, seen the term substance abuse expert, substance abuse professional, either one work. So SAE, SAP. This is a person. So the first step is the employee's non-compliant. They failed a drug test. We'll go with that example. They failed a drug test. They've tested positive. You as a company now need to come up with a return to duty plan for this employee. But you as the company are not qualified to create a return to duty plan for this employee because you're not substance abuse professionals. No fault of yours. That's just typically, I don't know of any companies who have a trained substance abuse professional on staff. So if you don't, then you get to outsource that to somebody. So we at Assure, we've got a couple that we work with, and they'll do this assessment virtually. About 99% of our substance abuse assessments are done virtually now. Zoom, FaceTime. I don't know if anybody uses Skype anymore, but they're done on camera. They can be done as easily as on an employee's phone. So what's great about this is that it's really accessible. There was a day back in the day where these were only done in person, and it got to be really difficult because people had to drive to their nearest major center, their nearest city, which was really difficult for a lot of people. So thankfully, most of these assessments are done virtually now. So it overcomes a hurdle or a barrier of an employee saying, I don't have time, I don't have money, I don't have a vehicle, all those things, they're overcome. Everybody's got a phone. Most of the world has a phone these days, so we can do these assessments. So again, why this is key is you as a company, what this assessment offers you is this is helping you understand what are the needs of this employee. Do they have an addiction or not? If they do have an addiction, is it mild, moderate, or severe? What are they addicted to? Because we need to know how to accommodate this person. Are we putting them back to work? Is it safe to put them back to work or not? What are we dealing with here? You as a company need to know some of that information. You don't need to know all the details. So that's an important piece to mention. And good for you as an HR manager, a safety manager, a company owner to know. Well, what do I need to know? What's my right to know? What's my right? What's a step too far? What's a breach of confidentiality? So no, you don't need to know the details of the person's personal life, but you do need to know as a company at the high level, what are we dealing with here? We're dealing with someone, here's an example. What you do need to know is this person has a moderate addiction to cocaine. You need to know that so you can properly accommodate that person. Is that person going back to work tomorrow or in a week or a month? When is it appropriate to put them back to work? So that's what this assessment is going to get you. At the end of it, you're going to know what are we dealing with, and you're going to get recommendations on steps to move forward from here. You as a company aren't qualified to do this. And even if you were, it's also good to remove yourself from that, to get that person assessed by a third party, not someone internal, where there can be, fingers pointed. An employee could say, you guys are just trying to get rid of me. This is punitive. This is I wasn't treated fairly. You got a third. You can remove some of that by saying we're getting a third party to do this assessment. We both agree that whatever this third party's assessment recommendations are, that's what we're going to adopt, and that's going to be our steps moving forward. So carrying on here with the steps. So the first step is they meet with this, and how this works is you as a company, you call us at Assure. Typically that's Carrie. You call Carrie and say, I need this employee. I need a substance abuse assessment. Carrie gets some information about you, about that employee. What's their name? What's their date of birth? Tell us some of the details, what happened. It was a post-incident test and they failed for THC and cocaine. That's about all the information she needs. Then Carrie will make the appointment with a substance abuse professional. And then we take it from there. We do it direct. You don't have to be in the middle of that. We set that up for you with the substance abuse professional. That's about a 2 to 3 hour virtual appointment that employee then has with the SAP. What they do in that meeting is he asks them all kinds of questions, questionnaires, and assessments that he does with them. He gets a history, drug and alcohol use history, family history. He gets a picture of what the employee, what their history is, and what we're dealing with, and then from there makes recommendations. So a question, and we'll get into that report in a second, what you get back from the company. So questions here are, what do we do with the employee during this time? At this time, they failed the drug test, or they've voluntarily disclosed a concern. At this time, the employee is removed from duty. You as a company can't just put them back to work. It's not just go back and drive that truck tomorrow, because things are kind of on hold. You're removed from duty pending further assessment. Another question is, what if the employee says, "Nah, I ain't doing that assessment. I'm not participating. I'm not doing it," for whatever reason. They say, I'm not getting on Zoom with somebody to do an assessment. Of course, they have that choice. Nobody's forcing anybody to do anything in this process. But if they choose not to do that, now they're impeding this the return to duty process. They're impeding the whole process. Because how can you as a company return them to duty in good conscience and good faith without the proper information? So this is what is needed to return you to duty. If you're choosing not to participate in this, that's your choice. But what you're also choosing then is you're choosing not to return to duty. Potentially ever. Because you as a company need the proper information. So if they choose not to do this, they're choosing not to impede the process, and now they're in non-compliance with the policy. And you're always referring back to your policy. What does it say if someone's non-compliant? What is the consequence? And typically it's removed from duty, and the consequences are could be up to and including termination for cause. You can't accommodate without first knowing what the concerns are and obtaining appropriate professional advice. So who qualifies as a substance abuse expert or a substance abuse professional? So this quote that I've got here on the screen for us is taken directly from the Canadian model for providing a safe workplace. The Canadian model is our best practice in Canada for drug and alcohol policy and procedures. So that's why we generally refer to the Canadian model. So they say who qualifies as an SAP is a licensed physician, licensed or certified social worker, licensed or certified psychologist, employee assistance expert, or drug and alcohol counselor. And they also should have received training specific to the SAE roles and responsibilities. They need to have clinical experience in the diagnosis and treatment of substance abuse-related disorders. And they have an understanding of the safety implications of substance use and abuse. So that's who qualifies. So a caveat that I will make to this, maybe it's not a caveat, it's just really an emphasis on something that's in here. Someone who's got specific training specific to the substance abuse expert roles and responsibilities. So here's what we've seen in the past is a company will say to an employee fails a drug test, company tells the employee, go to your doctor, go to your family doctor and get a letter that says you can go back to work. And sometimes that can be easy to get. Sometimes doctors don't want to deal with this. So we can get a variety of responses. Family doctors would be really quick to say, sure, they're good, go back to work. And then we just carry on. The company takes that, puts them back to work. We've got that letter, we put it in their file. That's kind of our insurance. We've got that letter in their file. And yes, that is something. and without a proper full assessment, which doctors actually aren't trained to do. They're not trained in addiction assessments. They're not trained to diagnose substance use disorders. That's not their specialty. Even some social workers are not. Even some psychologists potentially are not. So you get to do some research and find out who is giving the approval to this person to go back to work. So I say that to say we've seen some companies, not know how to properly deal with it and do the best that they can. And they can be missing out on some valuable information and putting people back to work a little bit too soon sometimes without getting an employee the proper help that they need. So we hand select our substance abuse professionals because these are people that have specifically been trained by the Department of Transportation, the DOT, in doing substance abuse professional assessments. And why that matters is the DOT is like kind of the gold standard in North America when it comes to drug and alcohol testing policy and procedures. Canadian model is always following and referencing the DOT. And when it comes to substance abuse professional assessments, that's the highest standard in North America. So we want to make sure our substance abuse professionals are trained to the DOT standard. So we hand select our people that are trained to that standard. And another reason why that being trained to that standard matters is because the DOT and the SAPs that we use understand workplace safety and occupational health and safety. And they understand the importance of and what this process is about. This process is about assessing this employee to determine fitness for duty at work. Not every physician gets that. Not every counselor gets that. We've also heard, I've heard stories like this many times over the years of an employee sends a person to a counselor and then the employee for an assessment in this return to duty process, then the company reaches out to the counselor and says, okay, well, can you give us a report? Can you give us an assessment? And the counselor says, I can't give you any information. That's a violation of their privacy. That's a breach of confidentiality. I can't give you anything. So they don't understand the process. So they're not giving the company the proper information that they need. So what they need is, again, just need the high level information. What are we dealing with here? I don't need to know about past traumas and abuses and things that might have led to addiction. I don't need to know about that. Company doesn't need to know that. The SAP is not disclosing any of that to the company. All they're disclosing is there a substance use disorder or is there not? If there is, what are your recommendations? Even if there's not, what are your recommendations? That's what the company needs to know. So carrying on with the steps, what happens in this process is first, an employee meets with the substance abuse professional. They do a couple-hour assessment. After that, the substance abuse professional provides us, a draft return to duty agreement. That comes with their recommendations. Sorry, they give us their recommendations, and then we turn that into a draft return to duty agreement that we provide to you, the company. That draft return to duty agreement says, it's got a section about workplace safety. We as a company, here's what we believe in. We believe in workplace safety. And then it's got a section on the recommendations that are provided by the substance abuse professional. Based on their assessment, it's going to say, I met with Joe, and based on my meeting with Joe, Joe has mild substance use disorder for THC, for methamphetamine, for alcohol, for example. Based on that, here's my recommendations. I recommend that Joe goes to 30 days of inpatient addiction treatment, and he'll also most likely recommend a specific treatment center in their community or close by to their community. So that's another beautiful thing, helpful thing that the substance use professional does is he actually makes recommendations and referrals specific to that person in the community that they're living in. So that's one example. He might recommend inpatient addiction treatment. He might recommend 12-step counseling. He might recommend 12-step support groups. He might recommend counseling. We take that and then we create a draft return to duty agreement that we provide to you as the company. And then what you do with that is that you take that and you have a meeting with your employee, they come in and they read it, you have a chance to discuss it, and then they sign it and will say, yes, I agree to abide by the terms of this return to duty agreement. If I want to go back to work, yes, I understand that I get to abide by this. They sign it, a company representative signs it. Now this forms the basis of the return to duty agreement. If they agree to its terms, they sign the document. Just carrying on with the bullets on the screen here. Once the pre-return to duty recommendations are satisfied, the employee may return to duty. So what that means is the substance abuse professional in their recommendation letter will say, before this person can go return to duty, they must attend inpatient treatment, for example, or they must attend 1 or 2 counseling sessions, for example. Another example could be they must pass a return to duty drug and or alcohol test based on what their problem is. And they must successfully pass that test. So once those return to duty recommendations are satisfied, now they can go back to work, but not until those return to duty recommendations are met. At this point, if the employee refuses to sign it, then they're not returning to duty. Because you as a company can't, again, in good conscience, safely put them back to duty or return them to duty if they don't agree to abide by the terms of this. So then the supervisor continues to support and monitor the employee upon their return to duty throughout the term of the agreement. The agreement might also say there gets to be some follow-up testing long-term. It might also say something like, and here's a common one, the employee agrees to 6 unannounced drug and or alcohol tests over the next 12 months. It might say 8, it might say 12 unannounced tests over the next 12 months. That's an example. That's what follow-up testing means. And follow-up testing again, in all the research that I've done over the years, all the years I've been doing this work, I've been an addictions counselor myself. I've worked in inpatient addiction treatment for many years. Follow-up drug and alcohol testing, unannounced testing, is one of the best ways that you can encourage somebody to stay clean and sober, is knowing that I could be called for a drug test at any time. I don't know when this might be. That's one of the best ways to help someone stay clean and sober. So some other thoughts on, just to go a little bit deeper in some things that may come up in the substance abuse assessment. A big piece of it, again, of this assessment is to find out, does this person have a substance use disorder or not? Because you as a company have a duty to accommodate an illness. Addiction is viewed in Canada as an illness, viewed as a medical illness, just like any other medical illness that comes to mind for you right now. Addiction is viewed that way. So you have a duty as a company to accommodate somebody for their disability, up to undue hardship. We'll talk about that a little bit more in a bit. So in order to accommodate them, you first need to know, again, what are we dealing with? Do they have a substance use disorder or not? Because you only have a duty to accommodate somebody with a substance use disorder. If they don't, you don't have a duty to accommodate that. So the substance abuse assessment, that professional may say, at the end of my assessment with Joe, I've actually determined he's not addicted to alcohol. He abuses alcohol. He failed a breathalyzer test after a post-incident test. He failed the breathalyzer. After my assessment of him, I've determined he's not addicted to alcohol. He abuses alcohol. That's a very important distinction because those two people are treated very differently. Someone who's addicted, you as a company get to accommodate that to the point of undue hardship. You need to offer a way back. You have to offer treatment. Someone who abuses, you've got some leeway there. We're going to get into that a little bit. I wouldn't say leeway. You would just treat that person differently. So that's a key distinction that this assessment is giving you. Addicted or do they abuse? We treat those people very differently. So we've talked a little bit about the recommendations from the substance abuse professional. pending their assessment, is it mild, moderate, or severe substance use disorder or no substance use disorder? Their recommendations are going to vary, of course. So they may recommend inpatient addiction treatment. That's where they may go for 30, 60, 90 days and actually live and be in a facility for that amount of time. Or they may say this person can go for outpatient counseling, 12-step groups. And then at the end of it, they get to provide proof of attendance, proof of completion. Again, we don't need to know all the details of what they discussed. All I need to know is high level. Did they show up? That's all that you're looking for on this. Did they successfully complete? Because sometimes people can show up for inpatient addiction treatment, but they leave after a week. That's not successful completion of inpatient treatment. So the recommendations, that the agreement will also say successfully complete, not just come for half of it. So again, the employer and the employee are going to agree to the terms of that agreement. So now let's talk about what is the duty to accommodate. So Canadian human rights says you as a company have a duty to accommodate under human rights legislation up to undue hardship. So again, a clear distinction is you must accommodate addiction, which here in Canada is seen as a disease, but not substance abuse. If the professional determines there's no substance abuse, or sorry, there's no substance disorder, there's no addiction present, this person abuses, at that point, you as a company get to determine how are we going to treat this individual, what are we going to do with them? Are we going to terminate? Are we going to move them to a different position? And the professional will also make some recommendations. So some common recommendations that we're seeing from the professional when there's no substance use disorder is they'll recommend education. This person, it's recommended they attend 2 hours of marijuana, appropriate, healthy use of marijuana, of alcohol. I'm paraphrasing some things here, but basically education about drug and alcohol use. And they should go to some counseling, and they should have a return to duty test at minimum. So carrying on here on the screen, in order to accomplish the above, the employer has the right to request fitness for duty information from the employee, a substance abuse expert, their physician, etc. The employer must determine if they can safely perform their duties. The employer may need to complete an independent fitness for duty assessment to gain sufficient info to be informed. So an example there, what that could look like is getting assessed by an occupational health physician, because sometimes this substance abuse professional will say, yes, there's a substance use disorder and there's more going on that I'm not qualified to deal with. We need a medical professional to diagnose and to deal with. So you as a company also have the right to go and get that information. So, and if you're comfortable with getting that from their family doctor, that's you may choose to do that. Or you may choose to say, no, we want an independent third-party evaluation. And we've got occupational health physicians that we work with that, again, understand the unique needs of your industry, of the workplace, and will work with you as a company to create a safe work plan for your employees. You, as a last point there, the employer also gets to determine if and how you can accommodate, or if you've reached the threshold of undue hardship. So a quick note on, what is undue hardship, because that's one of those purposefully vague and gray areas, because what undue hardship looks like for one company can be very different for the next company. So one quick example is if me as an owner of a trucking company, which just entails one truck. If my one driver for my one truck, that's my whole company, that one driver gets into an incident and goes through this process, and the substance abuse professional determines that there's a severe alcohol use disorder, and that person needs to be off for 90 days to go to treatment. Undue hardship, the courts is likely, and again, based on my research of court cases over the past few decades in Canada, the courts are likely going to say that for me as a small business owner with my one employee, my one truck, it's undue hardship to expect me to hold a position for that person for 90 days. Well, because that could potentially put my company under. So the courts might say, we've reached the threshold of undue hardship for this small business to say, you need to hold a position and promise them a position when they come back. They might say at that point, you can let that employee go. They may look at, that's how they may look at this company. But they can look at someone like Synovus very differently. Synovus has got many more resources, many more employees, more positions. They might have the threshold of undue hardship, again, it's going to look very differently, and the courts are going to look at those two situations very differently. That's just one example of what that looks like. So the last piece that we'll talk about here, and the four things I had for us to look at today, is ongoing compliance and monitoring. This is, one of the most important pieces in this. If there's one piece that I see fall apart most often, it's this one. Companies can be really good at getting them assessed, getting that return to duty agreement signed, and then they can just leave it there and kind of never look at it again. But what's just as important as getting it signed is over the next 6 to 12 months, or whatever the term of that return to duty agreement is, somebody in your company gets to be ensuring that this employee is being compliant with the terms of that agreement. So what, specifically what that might look like is, in the agreement, it says this employee will complete 6 unannounced drug and alcohol tests over the next 12 months. Somebody gets to make sure those are happening. And not just that they're happening, that they're actually passing those tests. That's an example. An example here is, are they going to their counseling sessions? The agreement might say one every 2 weeks for the next 3 months. Did they complete that? Somebody in your company gets to get a letter of compliance or a letter of attendance from the therapist, from the treatment center. Did they complete at the treatment center? Are they coming back to someone gets to stay in communication with this employee to make sure that they are compliant with the return to duty agreement? So a couple FAQs I've got for us here at the end. And if anybody's got questions, I encourage you to either put them in the chat or you can unmute. Now is the time to answer to make sure that your questions get answered. If you've got a specific situation that you're dealing with right now, I'm happy to discuss that. Just make sure you're leaving names and all identifying information out. But now is a chance to get some of your questions answered. So question I've got for us: what if the substance abuse professional determines the employee does not have a substance use disorder? We've already touched on this, but if they don't, then the professional is still going to give some recommendations. And again, what we're typically seeing is this employee gets to go for some education, and at minimum, they get to be doing a return to duty test. Now, you as a company could say, yes, we're willing to do that. We see that this employee is willing to work with us, is showing some desire to change their behavior. We're willing to work with this employee. Or you might use a company might say, based on this situation, we're going to end employment here based on this situation. So if they don't have a substance use disorder, that is something you as a company, the courts have shown, you do not have a duty to accommodate that, because that person has violated your company policy. So now that's what you as a company would be taking action on, is if you went that route, is this person violated the policy and we are choosing to terminate for the reason of violation of the policy. But again, it's another reason why getting a substance abuse professional assessment is so important, because you get to have that assessment back that says, I'm a professional, I've assessed this person, they do not have a substance use disorder. So another common question is, who pays? Who pays for, I'm just going to have a quick look at the chat in case there's a question based on what I just went over. Okay, not yet. So who pays? Who pays for that substance use professional assessment? Who pays for the follow-up testing? Who pays for anything that might come up? I think it's a really important question that you as a company get to have answered before you find yourself in this situation. And whatever your answer is, make sure that you're executing this equally across the company. So it's not, well, Joe pays for his assessment and then next week Susan doesn't have to pay for hers. You get to treat everybody fairly and equally in your company. So either the company pays for all of them or you don't. So what the courts have shown is the company does not have a duty to pay for any of this process. The courts here in Canada have shown that. So duty to accommodate, you have a duty to accommodate and to provide help, provide time off. That could be time off without pay though. But you have to, accommodation can look like giving the time. Accommodation does not mean you as a company have a duty to pay for this. Now your benefits program, your EAP provider may pay for some of this. So you could also look into that, something to look into. What is your EAP provider support? Will they pay for counseling for your employees? Lots of times they will. Will they pay for inpatient addiction treatment? Maybe, maybe not. Will your company cover that under, what does your short-term disability look like? You're going to be talking to your HR department about some of these things too. Short-term, long-term disability, look into that. But our EAP, it's an important thing to think about. And the follow-up testing, again, you don't have to. Courts have shown you don't have to. Many companies say we're going to pay for it, but I'm just telling you, technically, don't have to. But get clear on this before you find yourself in this situation and treat everybody fairly or equally. So another question I've got for us here, is the employee on leave during the return to duty process? So on leave, probably maybe isn't the best term here because that can mean some things specifically from an HR perspective, but are they going back to work is more what I was getting at with this question here. Or are they off duty? So yes, they are off duty. They are not going back to their safety sensitive position during this process. You may say you can come back and do some office work or do some non-safety sensitive work. You get to determine that. But they're certainly not going into safety sensitive work pending this process. So yes, it can take some time to get this assessment done. The substance abuse professionals that we work with, they understand the time sensitive nature of this. So we are getting people in within a day, within 2 days sometimes, because our people get it, and that we want answers quickly. People are waiting and off work and potentially off, without pay. But even if it takes a week or 2 weeks, yes, they're not returning to safety sensitive work until you as a company get the full picture and get all the information that you need before you can safely return them to duty. So again, another question here is, are they paid or not paid? There's no one answer here. You as a company get to decide that. Are they paid or not paid? The courts would say, don't have to. Another question I've got for us is, what if they don't comply with the return to duty agreement? So there's a couple areas of this. If they don't agree to sign it in the first place, then they're not going back to work, because you have to agree to abide by some terms here. Without that, we can't in good conscience send you back to work. So that is one quick answer there. What if they do sign it, everything's going great for a month, and then after 30 days, they say, I ain't going to my follow-up tests anymore. I ain't going to counseling. They leave the treatment center. They don't comply with what they said they were going to comply with. If at any point they're in non-compliance with that return to duty agreement, now they're also choosing to be in non-compliance with the A&D policy, and there's consequences for that. So yes, now again, we're back to kind of square one. You're not returning to safety sensitive duties because we don't know if you're fit for duty or not, especially since you're kind of stepping out of this agreement. You're not holding up your end of the agreement. Then you're choosing not to work in a safety sensitive position. What if they fail a drug test 6 months into a 12-month return to duty agreement term? Another great question. If that happens, immediately the next step is we book another appointment with a substance abuse professional to get them assessed again, to know what are we doing now. And nobody likes to hear this, but this happens. I've worked in addiction treatment for many, many, many years. I've got a lot of training in it. And I know that statistically, a person who wants to change their life, who wants to stop, who's addicted to drugs or alcohol or any substance, it takes 7 tries, 7 attempts at recovery, whatever that might look like. It doesn't need to be 7 stints in rehab, but 7 attempts to stop using before a person before it actually sticks and turns into long-term lasting sobriety. So the likelihood of a person relapsing is quite high. And I think it's so important for managers and companies to understand that, to have appropriate expectations here, to have appropriate expectations and to say, we understand this is a process. This isn't just a one-time thing. Go to that. It would be beautiful if it was just go to that assessment and life's all great, never an issue again. For most people, this is going to be a process. So the next step would be if they fail a drug test 6 months into a 12-month agreement, the next step is going to be immediately get that person assessed again. What do they need? Do they need to go back to inpatient treatment? Something's not working, so we get to change we get to up things. We get to increase the level of intervention here because clearly something fell apart. We're not going to shame or guilt this person about it. It's just something's not working. So we get to reassess. And you're removed from duty because we have a duty to maintain, a legal obligation as a company to maintain a safe workplace. So we have to remove you from duty and we're going to reassess. Now, what are we going to do? And then you would start again with another return to duty agreement. But the next step would be get that person assessed again, because again, the level of intervention clearly wasn't working. Something needs to be tweaked. So that's what I've got for us today. Again, if there's more questions, feel free to put them in the chat. For anybody who's here with us live, we are going to put this replay, send this out to our clients, to our list, and happy to get on the phone with you. Got my email and my phone number there. Happy to get on the phone and talk about any specific situations that you've got. If you want help with policy writing, I write policies, I review policies, and can give consultation around how to handle situations when it comes to return to duty situations, because I know they can be complex. They don't all look the same. We work with oil companies, we work with trucking companies, we work with a lot of First Nations communities, and each of your needs can be quite different. So happy to consult with you and to help you create a plan and enforce your policy in a way that really respects your employees who've got problems, but also respects the health and safety of everybody else in your workplace. So, been a pleasure.